Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be discussing your estate, and my guest is Jed Albert. He's a partner with the law firm of Farrell, Fritz, and he's head of their practice group in Trust and Estates. Farrell Fritz is also one of the largest law firms on Long Island, and he was recently named as the Legal Eagle for Trust and Estates by Pulse Magazine. Jed, welcome to Law You Should Know.
Thank you, Ken. Nice to be here.
In terms of your area of practice, and what I'd like to help our listeners to learn about, what is part of their estate?
Well, that's a good question. Their estate encompasses the assets that they own at the time of their death. Typically, well, actually, you can use the expression estate even while you're alive, but in the context of trust and estates and planning for what happens when a person dies, we think of it as the assets that a person owns at the time of his or her death. And it can include everything that he or she owns, anything, any property, furniture, furnishings, jewelry, artwork. We call those things tangible personal property. Investment-type assets, cash, bonds, stocks, and so on. Those we call intangible assets. Real estate is an asset. And there are many diverse ways that one can actually own assets, and interesting questions as to how the title is held that determine what happens when a person dies.
So if the title, and this is where the title's in their name, whether it's real property, a bank account, a stock, or something else, what's on the flip side, what kind of assets might pass outside of their estate?
Sure. So title can also be in several people's names, too. So, for example, my wife and I own a house together, and as is sort of the common practice, it says Jed Albert and Sharon Albert, his wife. That refers to one way one can own property, and when one dies, that property automatically passes to the surviving spouse. So that the fancy title for that is tenancy by the entirety. We also refer to that type of passage of property as joint with survivorship, but in New York there's a special thing called tenancy by the entirety that applies just to spouses.
And if someone has a bank account, the bank account by its title might pass on to a beneficiary. That's
right. So let's move now from the question of two co-owners together, which you can have on a bank account too, and it can pass that way too. Jed Albert and Ken Landau as joint tenants with right of survivorship. I die, it automatically goes to you. Or I can have a beneficiary designation. So pay on death, we often call that POD or TOD, transfer on death, to Ken Landau. So while I'm alive, I'm 100% owner, but when I die, it automatically goes to you.
And this might be a 401k or a life insurance policy or something along those lines.
So with 401ks and life insurance policies, IRAs, those are by beneficiary designation. And so, but the concept is the same thing. I have a life insurance. It's a contract with an insurance company, and it says when I die, pay Ken Landau, whatever it is. Same thing with IRAs and 401ks.
But if there was no beneficiary, the beneficiary had predeceased you, then it would go through your estate.
So the first thing we often want to do, by the way, when we're counseling people, is we want to make sure that we have beneficiaries designated and contingent beneficiaries, so that in case the sometimes unthinkable happens, another person dies before you. But then if you have no beneficiaries, whether it's one or several, and they all died before you, then it goes into your estate and passes under your estate. Now, the word estate is sort of a nebulous term, I realize, and I think we'll have to sort of define it a little bit more. And I think that's the purpose of what you...
If you can, just simply and quickly, just define it.
So we can talk about the estate in a broad concept of, anything you own, as I did at the outset, when you die, and all these things are part of your estate. But the question is, Now, how does stuff pass when you die? If you don't have a beneficiary designation, if it's not jointly held with somebody, there's no POD, pay on death, or TOD, transfer on death, and it's just in your name. You die, it goes under, if you have a will, and we call that your testamentary estate. It's a fancy word, your last will and testament, and it passes underneath your will, and we call that your testamentary, or as I said before, or probate estate, and that's how that happens. If you don't have a will, there's a process in New York called estate administration, which says, well, we got to find a way to pass this property. It's in the person's own name. We're going to call this your intestate estate, and that passes under the laws of the state of New York.
So, in other words, if a person has a will, with certain exceptions, that's their estate plan, and that will is going to be submitted to the surrogate's court to probate the will to make sure it's proper and in proper form and represented their intent. And then once it's approved, the court or the people handling the estate, we'll talk about them in a second, will distribute the property according to your plan.
Exactly.
If you don't have your own plan, the state has a plan for you.
That's right.
And again, the court has to approve it and appoint who's going to make the decisions, and then they'll have to follow the state's plan.
The state tries to think in a generic fashion what most people would want under a certain set of circumstances as who should get, and it's usually by, blood relationship.
But you may not want that plan, and you can opt out on it as long as you have a will while you're able to do so.
Ken, that is so important. That's absolutely right. And let me just give you a quick example as to why that could, result in a problem you may want to opt out. If you die in New York without a will and you have a spouse, husband or wife, and children, guess what? The first $50,000 goes to the spouse, and then the rest goes 50-50, half to the spouse and half to the kids. Most people I know, and this is all I do for a living for the past 30 years, most people generally don't want to benefit the kids. Their primary concern is to benefit their husband or wife that they've built things together with. And so you really want to opt out in that case.
And also the kids would get equal shares, and you may or may not want that to happen.
Exactly.
Or you may have other relatives who be entitled. It's too long to explain now, but so you automatically have a will, but if you want to opt out, you need your own will.
Yeah, that's right. If you want to grab control and make sure that your stuff goes the way you want it to go, you really want to have a will.
So again, with your will, it is your way. So what is, in terms of probate, someone's going to give you the will. It's important they don't tamper with it, pull it apart. You probably want the original document, and you're going to help them submit it to the court.
That's right. That's exactly right. You want the original document. Be careful, folks out there, if you have a will. I remember I was a young lawyer when this first happened to me, and somebody gave me a will that they had, and the staples were out. Think about it. The staples were out, and I, a young kid, green behind the ears, will go to the court, drop it off, and the surrogate's court clerk says to me, "Oh, we got a problem here. The staples were taken," and it was restapled. Well, I could have had a heart attack at the time. I was so freaked out. And, of course, if you think about it, the court has a reason to be concerned. It looks like it could have been tampered with.
And they don't know who did that.
Now, in most cases, people do it to make copies.
And people don't realize it, but it's important. Don't write on it. Don't rip it. Don't spill coffee on it. Don't pull out the staples.
Absolutely.
Don't tamper with in any way.
Absolutely.
And so, and of course, there could be different copies, but that's...
Well, a copy is just a copy. By the way, I just want to come back to one thing, because I want to drive a point home here. We often use words, human nature, without really thinking about them. But think about the word will. It's your will. We always say, we think about a will as being a piece of paper stapled together. But guess what? It's called your will because it's your will. It embodies what your wishes are. So I just want to drive that point home.
Right, and you're giving a plan in that will. So as part of submitting a will to probate, the court will issue authority, and it's in the form of a letter, like an authorization for someone to act on behalf of the estate. So explain about what that means.
Well, that's a good point. Just because you have a will doesn't mean it's already recognized by the law as a will. So if I die next week on Tuesday, and my wife takes my will out of, let's say it's in a safe deposit box or wherever it is, goes to the bank and says, "I want to collect Jed Albert's $50 million account. I've hit the lottery." They're going to say, "Well, that's very nice, but how do we know that will is valid?" The court needs proof that the bank needs proof that the court accepted it. So what the process of probate is, the will gets filed in court. The next of kin are given an opportunity to object to the will. And then when they don't object to the will, which is typically the case, and maybe you might want to come back to that later. But in any event, then it's a fairly pro forma, straightforward process, and the court issues what are called letters testamentary. If nobody's objected, the court, on its own volition, typically doesn't challenge a will. It's up to the next of kin to say we have a problem.
And that's the important point. So people will be put on notice that a will's going to be off for probate if they don't think it's a proper will, or there's a later will or another will. That's their time to come to the court or get a lawyer to represent them to challenge the will.
Exactly, Ken. And the people that we're talking about are the next of kin. We're talking about the people who, under the laws of the state of New York, the next of kin are the people who would take property were it not for the fact that there is a will. They have the economic incentive to challenge a will. So when they consent or fail to object, then then the court can act.
And sometimes there are valid reasons for challenging a will. It's a little beyond what we can go into now. Now, if someone does not have a will, there might be affairs of the person who passed away that need to be dealt with, or the property has to be passed on or distributed. Mm-hmm. So that can't happen automatically if it's part of the estate. So the court will appoint someone to do that. So just explain that.
So that person is called an administrator. And it does very much like what an executor does under the terms of a will. Administrator administers the affairs of the estate. And it's usually the next of kin, a close family member, who's appointed to serve in that role. And in either case, the role of the executor or the administrator is to, A, determine what the decedent's assets were in the estate. That's to say, all the assets that don't pass automatically to other people. Find out what they are, convert them into the name of the estate, open up an account at an institution, and convert everything into the name of the estate of John Jones or whoever the person is, and value the assets. And
they can't do it until the court gives them authority. So someone's going to apply. Everyone else who's a relative who would benefit under normal circumstances is put on notice in case they object. Mm-hmm. And they can contact the lawyer or object on their own, but they must object then or forever hold their peace.
That's right.
And then that person is given, assuming no objection, that person is given authority by the court.
Correct. The court issues what are called letters testamentary or letters of administration, and now that person, let's say it's my wife in this example I used before, goes to the bank and says, "Here's my authority from the court. The court has approved me to be the executor of the estate of Jed Albert. Give me the $50 billion. I just added another.
And they can sell houses, they can operate businesses, whatever, collect debts, pay out debts, whatever needs to be handled to take care of the affairs of the person who passed away.
Because now the executor now has legal authority to act. That person is called a fiduciary. It means he or she represents the interests of the estate. And
just going back to wills, not only can someone give their plan, they can appoint who they would like to do that for them. So it might be their accountant, it might be their lawyer, it might be a trusted friend, it might not be their spouse or children. They can appoint someone who they trust, have faith in,
whomever they like. I'm going to a house.
So again, with a will, it's your way. If not, the court's going to follow a certain formula.
Yeah, I have a situation that was presented to me this week. I have a longtime client, worked for him for 25 years. They had their daughter be the nominated executor. Well, guess what? She's come down with bone cancer, and she's in bad shape. So they've decided they want to appoint their accountant to be. So we change. I'm going to the house tomorrow morning. We're going to sign it all up. It's whoever you want. Doesn't have to be.
And it's good to have a backup, and you can have two people share the responsibility.
Absolutely.
And if the people die who you named in the will, or your circumstances change, you may want to update the will to prevent the problem, and so you retain control.
Exactly.
We're going to take a short break now. We'll continue our discussion of your estate and what happens in the handling of an estate. Our guest is Jed Albert. He's the practice group leader and a partner at the firm of the Farrell Fritz here in Uniondale, Long Island, and he is an expert in trust and estates. You're listening to Law You Should Know here on 90.3 WHPC and also over the internet at ncc.edu/WHPC. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, helping both the public and lawyers since 1899. They are the largest suburban bar association in the country. The Nassau County Bar Association offers clinics where you can meet privately with an attorney to prevent or solve legal problems involving Hurricane Sandy, foreclosure, wills, or elder law. Speakers on almost any legal topic are also available to schools or community groups. They can also help lawyers advance their legal careers and offer a place to network. Learn more about the Nassau County Bar Association by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking about your estate, what happens to the property of a person if they pass away, and our guest is Jed Albert. He's the